all eyes were on the Supreme Court today to see if they would intervene and ban netas with criminal charges from contesting elections. They did not. Instead, the court said Parliament has to make a law and not the court. The 5-judge bench, led by the Chief Justice, said it is the duty of Parliament to keep money and muscle power at bay. Parliament should cure the malignancy, and it is not incurable before it becomes fatal to democracy. Though criminalization in politics is a bitter manifest truth, which is a termite to the citadel of democracy, the court cannot make the law. They also said the Election Commission cannot usurp the power which it does not have. However, the court was clear that the time has come for politicians to act against their own and set aside winnability in favor of infusing purity in politics, as they put it. And so they said the following directions have to be followed: that candidates contesting have to fill up a form that's provided by the Election Commission, which must state very clearly in bold letters any criminal cases pending against the candidate. The candidates have to inform their parties about pending criminal cases against them. Parties in turn have to put up all that information on their websites. And candidates facing criminal charges and their parties also have to publicize this information widely in the print and electronic media. This is what the Supreme Court has directed today. So is it going to work? Should the court have intervened, or did the court actually look at this much more dispassionately and actually do the right thing? Let's talk about this debate tonight. We have S.Y. Qureshi, the former Chief Election Commissioner of India, joining us tonight. Dushyant Dave, Senior Advocate of the Supreme Court. Mr. Jagdeep Chokar, the founding member of the Association for Democratic Reforms, a think tank, an NGO that has been working closely on these issues. Jervi Shergill of the Congress is here with us, and Hitesh Jain, lawyer and member of the BJP, also joining us tonight. Mr. Qureshi, to you first. Do you think that the Supreme Court should have intervened today? I know a lot of folks do feel that the Supreme Court should have done more, should have, stopped netas with criminal charges from contesting. But there is a more nuanced argument to this.
Certainly, it was not a very straight case. It was a complicated case, but only the complicated cases go to the Supreme Court, and it has to take a call. Whatever transparency has happened in the electoral system in the last 20 years has been thanks to the Supreme Court. For instance, we never knew about the criminal cases pending against the candidate till the Supreme Court, in a judgment in 2002, said that every candidate has to, while filing his nomination, has to file an affidavit giving the details. That's how we got to know that they have criminal cases. Now, the main argument is that the law of the land is that you are innocent till
proven guilty.
Till proved guilty. Very true. That is the law of the land. There is a counter question which nobody has answered so far, and I've asked the juries, I've asked the lawyers and the judges. In Indian jails today we have 4 lakh prisoners, of which 2,70,000 are under trial, which means yet innocent because not yet convicted. And you have taken away 4 of their fundamental rights. Fundamental rights, I repeat: right to liberty, freedom of movement, freedom of occupation, right to dignity. Now,
and yet the same doesn't happen to politicians facing serious charges.
You can take away 4 fundamental rights of 2,70,000 people within the ambit of law, where the presumption of innocence prevails. But right to contest election is not even a fundamental right. What if that gets suspended? Why not? So now this was the case. Judiciary is sometimes accused of the activism. I think this was a good case where activism would have been very, very popular, would have gone down very well with the people, because asking the Parliament to make an act, forget about it. Next
it's not going to happen.
I'll tell you why.
But the Supreme Court shouldn't do what the people, would want it to do.
No, quite right. Because
that's not how the court should function.
Basic principle of Supreme Court judgment is that the making of law is the prerogative of the legislature. That is fine. But the Supreme Court also has been laying down law. And
like 377, yeah.
Why I think it will be increasingly difficult? Because in present Parliament, we have 182 MPs who have criminal cases pending against them. And this figure has been going up and up. It was 162 and 124.
Okay, you've made a very interesting argument. Dushyant Dave, would you agree with Dr. S.Y. Qureshi here? Well, we don't have Mr. Dave. Let me ask Mr. Jagdeep Chokar. Do you agree with what Mr. Qureshi is saying, that this was an opportune a moment perhaps for the Supreme Court to intervene and lay down the law and say that no, those facing criminal charges cannot contest? Dr. Qureshi argues it's not a fundamental right and therefore not necessary. Mr. Chokar.
I fully endorse and agree with what Dr. Qureshi has said. And there is more to it than meets the eye. You read out the 5 directives that the Supreme Court has given, that a candidate has to fill up a form, it has to be put up out in the public domain. All that has been happening since 2002. There is nothing new there. Supreme Court is reiterating what its own judgment said in 2002. On the other hand, where the Supreme Court has restrained itself or not done what it should have done, the 2002 judgment also was based on this principle that if there is a gap or infirmity in law, number one. Number two, if the legislature has not had time or inclination to fill that gap or to correct that infirmity, and number three, which is the most important, if the public interest is suffering. Under these 3 conditions, the Supreme Court or the judiciary has a right, and some judgments say they have a right, nay, a duty to fill the gap in legislation or correct the infirmity till the legislature does so. I do not understand what was preventing the Supreme Court from saying that people who have cases in which the punishment is 5 years or more, in which charges have been framed by a court of law, and the cases were filed more than 6 months before the election, those people will not be allowed to contest elections till such time as the parliament makes a law on this subject.
Okay,
Supreme Court has been
I understand what you're saying.
Supreme Court has been over-conservative.
Over-conservative.
Has
Okay,
been
you're not mixing your
over-conservative.
words about how you feel about this order today. Dushyant Dave joins us now. Mr. Dave, Dr. Qureshi and Jagdeep Chokar both maintain they feel this was a missed opportunity in a sense by the Supreme Court. The court was over-conservative, as Mr. Chokar puts it, that it should have intervened, and politicians who are facing serious charges should not be allowed to contest elections. The counter argument to that, that has been put forward, is that very often in India, political vendetta is a real thing, where opposition parties throw cases, slap cases on their opponents all the time, and this can drag out in court for many, many years. Is that a valid argument, Dushyant Dave?
Well, let me say one thing, that personally speaking, I would have also really liked to be, if the Supreme Court had taken the view that all those who are facing criminal cases should be debarred, and especially those serious criminal cases. But that's not what law should be. Under the Constitution, Article 102 or Article 191, in respect of members of Parliament or members of the Legislative Assembly, categorically provide disqualification, and one of the disqualifications which is provided is what will be prescribed by law made by the Parliament, or now the Parliament has enacted the law, and Parliament law clearly provides that it is only on conviction that disqualification stands attracted. It would be therefore impossible to conceive that Supreme Court should have said that merely filing of an FIR or even filing of a charge sheet would be sufficient to really disqualify a candidate from being a member of Parliament or being a member of the Legislative Assembly. So I think the Supreme Court's view is an absolutely correct, a legalistic, a constitutional and lawful view. Now Supreme Court has not just stopped there. Supreme Court has requested Parliament to step in to stem the rot which is there in public life. 2, Supreme Court has said the Election Commission has sufficient powers, and most of all the Supreme Court has given guidelines which are according to me fairly good, where they have said that look, the candidate must disclose very categorically, boldly in his form as to which cases are pending against him. The political party to which he belongs must on its website disclose that these are the cases pending against the candidate, and that the political parties must issue as many as 3 advertisements in national dailies or important dailies disclosing that my candidate has these criminal cases pending against him. I think this is what the Supreme Court has done. Beyond this, Supreme Court could not have done anything more. I don't agree with my distinguished friends who have said that Supreme Court has been conservative. I think Supreme Court is a court of law. It can't really take law into its own hands. It is left to the Parliament, and Parliament must act. Unfortunately, Parliament won't act.
I think that is an interesting argument as well, and I want to ask the political parties tonight. Mr. Chokar, I'll just come back to you in a moment, but Hitesh Jain, if you look at then the question of whether there is a political will as far as parties are concerned to be more responsible in how parties choose their candidates. Now, if you look at the statistics that the ADR, the Association for Democratic Reforms, has actually put together, currently you have MPs who have declared criminal cases in Parliament. Obviously, the BJP will have the largest because it is the largest party. So 107 MPs who have criminal cases from the BJP, followed by the Shiv Sena at 18, the Congress at 15, etc. So in the Lok Sabha, there are 21% of MPs with serious criminal cases against them. So these are not just criminal cases, but serious charges. And in the Rajya Sabha, about 9% of MPs have serious criminal cases against them. The point is, Hitesh Jain, does Parliament have the will to really act on this? Do parties individually have the will to be more discerning about who they choose to give tickets to?
I will answer the question beyond the statistics, and I want to give a short background. In 2013, the division bench of the Supreme Court had asked the Law Commission to submit the report on the criminalization of politics. The Law Commission submitted its report, and in the report the Law Commission stated that the trial takes undue long time, and therefore this whole ground under the Representation of People Act, where conviction is a ground to disqualify, is no longer sufficient, but you should look at framing of charges because this is a court observed process. So what is the reasoning given by the Law Commission? That is the delay in the trial. So what we should also focus, because in the criminal justice system, the presumption of innocence is also important, and we cannot ignore, because this is a very important right of an accused in the matter. When we act on such only on the basis of charge sheet or of the charges, we straight away come to the conclusion that he is a guilty. So what will also be important is if we can also ensure that the cases against the politicians can be conducted in the fast track manner, and we can try to finish those cases in a time bound manner within a year or 2 years. Now this is something which is very easy. The government has set up the fast track courts, and in fact the government is of the view that the ball is also in the Supreme Court hand as to how they can monitor those cases pending against different politicians and ensure the conclusion of the trial in the time bound manner. So if you can
Mr. Jain,
ensure
can I ask you,
can
ask you
whatever
what
the conviction
Dr.
or
S.Y.
the
Qureshi's
acquittal can
counter
come,
argument
and
to
this
that
issue can be addressed.
No, you're making an important point, but what S.Y. Qureshi has argued just now before you came on is that when you have lakhs of under trials, more than 2 lakh under trials, 2,70,000 under trials who are also not convicted, who have their fundamental rights suspended currently in Indian jails. His point is, standing for elections is not a fundamental right. So why should politicians facing serious criminal charges be allowed to contest? What would you say to that?
Well, in the same manner, how will you draw a distinction between a politician and those criminal, that for one set of people you have the presumption of innocence, and for another set of people, merely because they are politicians, the presumption of innocence doesn't come? What Mr. Qureshi is saying in rhetoric or in theory, it is, we can applaud that, but in law and practicality, you cannot draw such artificial classification in the set of criminal merely because you have a politician, you have one set of laws, and for the citizens you have another set of law. Because when you commit a crime, you are not a politician or this thing. Everyone is equal before. The law deals with you as a criminal, and it does not draw a distinction. There is no special power conferred on the politician, neither it has got a special powers to take certain rights of the people. So we have to look at, this is an issue you have to look at from the balancing and the constitution, the provision of Article 102 or Section 8 of the Representation of People Act. There is some reason where the Parliament has got across.
Okay.
I'm glad Mr. Jain has brought in the question of equality. Now, if there is equality, if Mr. Jain applies for a government job with a pending criminal case, will he be considered? And there was a case in the Supreme Court of a CVC, just because the case was pending against him, pending, no decision. On that basis, he was unseated by the Supreme Court, no less. Now, if you have double standards for different people, for a CVC candidate, for a general candidate, for an MP, so the question
Now,
of
Mr.
equality is
Qureshi,
being
whether
violated.
it is a government or the private job, when you have a pending cases, there is a common law applicable for everyone.
But then perhaps the Supreme Court, like you said, has to also then apply itself more uniformly.
Correct. Also,
which-
you know,
which
there was
it-
another case
yeah.
in which Supreme Court had talked of institutional integrity, and it was in the context of Parliament only. Now, institutional integrity is very important thing. With 182 MPs and the number going up every election,
what is
about
the integrity that's
of
left? So, Jayaveer, what would you say to that? Because when people look at how Parliament is structured today, I just gave you the parliamentary statistics. If you look at the statistics of MLAs, and this is, you know, state assemblies, you have more than 1,300 MLAs who have declared criminal cases against them as per the Association for Democratic Reforms. Now, that kind of stuff makes people wonder, you know, who are the kind of people we are electing? Are we electing responsible people into positions of power?
The first on the judgment, as a lawyer also, I think the Supreme Court has struck a fine balance between the right of a under trial, a victim of a conspiracy, and the need to infuse cleanliness into the political system. You asked a very pertinent question, awareness in the will. The name and shame guidelines which have been issued by the Supreme Court will definitely act as a deterrent on political parties when it comes to giving tickets. Number 3, in a serious appeal, voter awareness. The voter of this country also has to make pending criminal cases as a deterrent to not to vote for this particular candidate. Now, you giving me study 451 MLAs out of 1451 MLAs in the state for BJP and a less number for us. But people have elected them and sent them into the court. So, the voter awareness should also increase. Number 3, before the law also comes in, the parties within themselves have to infuse. You remember how Mr. Rahul Gandhi was criticized for tearing that ordinance which was changing
Well,
the law.
Why he was criticized for that, but that's another issue.
On his method. But the step Mr. Rahul Gandhi took to clean politics is being echoed in the Supreme Court judgment today. Within our system.
Sorry,
Yes.
you've got 203 MLAs with criminal cases in assemblies.
No,
today.
Mr. Shergill,
And you-
when
and you
Rahul
have
Gandhi
15
allies
MPs,
with Lalu Prasad
15
Yadav,
out of your
who's a
almost 50
convicted
MPs have
candidate,
serious
it does
criminal,
not
declared
it-
criminal
I
cases.
do not agree with
Mr.
you.
Hitesh,
So how did
Mr.
Rahul
Hitesh,
clean it
I
up?
did not outshout you. If anybody who should not be speaking in this channel
Jayaveer
is you,
Shergill, you are-
because
you
you
are
have
contradicting
31%
yourself. So
with
in Bihar, when you
21%
ally with
heinous
Lalu
crimes
Prasad
against
Yadav,
women.
You
who's
guys
a
can't
convicted
compete on who has
candidate.
who
So
has
at
more
that
people
time
with
you are
criminal cases against
conveniently
them.
Didi,
ignoring the
I
law.
am,
It's a terrible
I am
comparison.
today
Yeah.
questioning, you have questioned the will. What
Yeah.
I am saying, committing on your channel, will the government who immediately in a jiffy brought the Land Acquisition Act, brought a law for triple talaq, will they show the same enthusiasm to bring this law? Congress party will support them.